This program is brought to you by Emory University.
Welcome back, everyone. I'm Julie Seaman. I have the honor of moderating this very distinguished panel. I'm going to give you very, very brief introductions because I want to save plenty of time for the talks. And also, if you notice me gently nudging the speakers, it's just because I've been asked to keep a pretty strict time. Also, if you see me looking at my phone, I promise I'm not checking my email or Facebook. I'm just keeping time. So in order that they'll be speaking, I'm going to introduce them. First, we have Laura Weinrib. Laura is a professor of law at the University of Chicago Law School. Next, we have Alexander Tsesis. I hope I said that correctly. Oh, no, I'm sorry. Wrong order. Next, we have Fred Schauer, the David and Mary Harrison Distinguished Professor of Law at the University of Virginia. He's also Frank Stanton Professor of the First Amendment, Emeritus, at the Kennedy School of Government at Harvard University. Third, we have Dean Erwin Chemerinsky. Dean Chemerinsky is the founding dean and distinguished professor of law and Raymond Pike Professor of First Amendment Law at the University of California-Irvine School of Law with a joint appointment in political science. And finally, now I'm going to say it again, hopefully correctly, Alexander Tsesis. He's a professor at the Loyola University Chicago School of Law, where he teaches constitutional law, First Amendment, civil procedure, and seminars on civil rights and constitutional interpretation. So first, we have Professor Weinrib, and let's welcome all our panelists. Thank you.
Thank you so much for everyone who made this event possible and for being here today. The topic of this symposium is the new age of communication, freedom of speech in the 21st century. And usually I listen to instructions really well, but I'm about to give you a talk on the 1930s, which is decidedly the old age of communication. I hope, though, that it will have some important implications and resonances for the debate about future directions in the First Amendment and in thinking about free speech. The talk I'm giving grows out of a book project I'm working on the history of civil liberties between the world wars. And in the book, I argue that it was during this period that the modern concept of civil liberties took shape. And by that, I mean a concept of free speech as a judicially enforced right asserted against the state. And I'm going to focus today on one element of that project, namely the diversity of understandings of civil liberties during the New Deal. This modern understanding, I argue, was not the only one in circulation at this time. It was not even the most central one. So before I describe these competing visions of civil liberties, I want to give you a sense of why they matter. There is a growing focus today on what many have called the Lochnerization of the First Amendment. That is, the use of the First Amendment to challenge social and economic regulation in areas ranging from labeling laws to union dues to campaign finance. And that's led to an increasing sense among some scholars that maybe a strong First Amendment coupled with a counter-majoritarian judiciary is a bad combination. It's also led to a lot of agonizing over the cost to civil liberties of deference to the elected branches. What I want to suggest is that while there may be good theoretical reasons for all that agonizing, and that's a question I largely leave to my fellow panelists, the historical ones are much less compelling. So today, virtually all First Amendment scholarship assumes that the courts were inseparable from the First Amendment tradition of expressive freedom and minority rights that emerged in the aftermath of the First World War. They assume that Caroline Products was an unequivocal victory for advocates of disfavored minorities and of radical dissenters. And it turns out that that's not true. During the New Deal, even the staunchest advocates of what they called civil liberties had deep misgivings about judicial power. Many imagined and administered alternative regimes for civil liberties enforcement. methods that marshaled state power to counteract distortions in the marketplace of ideas and to advance substantive rights. So Professor Follick started us out here by saying that there was no constructive critique of corporate domination of the marketplace of ideas, which was absolutely true during the period he was discussing, the 50s, 60s, 70s. But during this period that I'm discussing, that was not yet true. And in fact, there were two solutions that were very seriously considered. One of them was to jettison the First Amendment altogether, and to jettison correspondingly the courts as an enforcer of the First Amendment. The other one was to read the First Amendment to require meaningful free speech, which meant intervening to equal out opportunities for communication. We've forgotten about these alternative paths, in large part because everybody involved was using the term civil liberties to describe what they were doing. But they were using the term to describe fundamentally different substantive agendas. Okay, there's another surprise in this story, which is that advocates for Lochner-style property rights were instrumental in crafting the modern understanding of the First Amendment. In the run-up to the court-packing plan, the ABA hired PR specialists who told them that the best way to defeat court-curbing legislation was to start celebrating the civil liberties decisions that they had long proposed, basically to deflect charges of judicial hypocrisy, that it was only protecting property rights and not personal rights. After the switch in time, which meant that property rights would no longer shield economic activity from state regulation. Groups like the National Association of Manufacturers, the U.S. Chamber of Commerce came on board too. They started claiming that First Amendment rights to lobby government and to distribute anti-union propaganda shielded their activity from state interference. Okay, so I'm going to begin to sketch these views by starting us out in medias res, in 1937, which is a key moment in this story. And I'm going to start with a report by the American Civil Liberties Union, an organization we're all familiar with and that today is extremely committed to what we think of as an absolutist vision of the First Amendment, enforced primarily through the judiciary. So the ACLU issued a report in May 1937, just after the Supreme Court upheld the constitutionality of the National Labor Relations Act, or Wagner Act. This is a monumental moment in the history of the New Deal and in constitutional law. And in stories about the court-packing plan, it's cases like these that are typically discussed. Roosevelt was worried about rescuing his New Deal economic legislation from Lochner-style substantive due process decisions based on freedom of contract and property rights. But this ACLU report was not about Jones and Laughlin Steel, which upheld the Wagner Act. It was not about West Coast Hotel v. Parrish, which upheld a Washington state minimum wage law, at least not explicitly. This was a report on, quote, how far the court has been a defender of civil liberties. And the report evaluated the court's record in civil liberties cases since the 19th century. What it concluded was that the court, I'm quoting here, had more often failed to protect the Bill of Rights than to preserve it. It reported that the court was much more likely to uphold property rights than personal rights, like free speech. It did make some allowances for the fact that the First Amendment was changing, in large part due to its own work, but it was very equivocal, deeply divided. There were many within the ACLU who actually supported not just the court-packing plan, but went so far as to support getting rid of judicial review altogether. Okay, so the ACLU's report is a striking document. It represents the organization's effort to grapple with one of the most fundamental and divisive questions facing civil liberties advocates during the 1930s, whether efforts to defend civil liberties should proceed through the legislature, through government agencies, or through the courts. If we fast forward just a few years, the ACLU looked much more like the organization we understand it to be today. Quotes from 1941 annual report suggested that the ACLU's battleground was chiefly in the courts and that the United States Supreme Court, quoting, in case after case had firmly established the interpretations of the Bill of Rights which the Union supports. Okay. What I want to focus on today is not how we get from 1937 to 1941. That's a project that I am studying, and I'll gesture to some of the implications. But what I'm going to focus on today, rather, is what the alternatives were that were being floated during this period. And to that end, I actually want to take us back earlier now to the origins of the modern civil liberties movement in the wake of World War I. And the defining feature of the interwar civil liberties movement in the United States was its obsession with labor relations. Over the course of the 1920s, the ACLU expanded its operations into areas like academic freedom, artistic expression, and sex education, in which they could get broad-based consensus. But what really motivated them during this period was the labor struggle. And in fact, the ACLU called itself a frank partisan of labor in its founding documents. Now, this was less about defending the rights of labor radicals to spread their propaganda, the sort of familiar idea of the soapbox orator or the pamphleteer. That was part of it, but what they were really worried about was defending labor's right to organize, to picket, to strike. That included a lot of activity that wasn't conventionally understood as speech. Frankly, activity that still isn't understood as speech. They used the term the right of agitation to define what they were talking about here. This was a right to secure fundamental social and economic change through economic weapons without state interference. And what they were after here, I'm going to talk a little bit obliquely about this, but they were after the general strike. This was a very anti-statist vision. It was inspired by the IWW. Okay, needless to say, theirs was not the only view. What they were engaged in was coalition building with others who were sympathetic to some aspects of their projects, but not the project necessarily as a whole. Conservatives during the 1920s were pretty marginal in the Civil Liberties Coalition, though they would play a bigger role in the 30s and were starting to emerge in certain areas. Progressives, however, played a central role, and by progressives here I mean in the historical sense of the term, those who advocated typically state interference or state intervention to correct social and economic problems. And for many of progressives, civil liberties served to buttress rather than to undermine state power. The Civil Liberties Coalition turned increasingly to the courts over the 1920s, but they did it very reluctantly and with lots of internal pushback. Now, during the 1920s, progressives and radicals were shut out of power, so the disagreements among them were relatively unimportant. The New Deal changed all that. So over the course of the decade, there would be many splits in the Civil Liberties Alliance. The most important one was over New Deal labor policy, and it involved competing attitudes toward state power and toward the federal courts. So now a brief interlude here on New Deal labor policy. So New Deal efforts to regulate labor relations shared a defining feature, and that was a strong role for the state in brokering disputes between workers and their employers. This was a substantial departure from labor's longstanding skepticism towards state intervention in these issues. So we associate the sort of state skeptical labor vision with the American Federation of Labor. This is the driving idea behind what's known as labor voluntarism. Also with certain groups of labor radicals, though not all of them, but groups like the IWW that advocated direct action instead of political action. And previous measures to protect labor's rights had sought to shield the labor struggle from government intervention, including judicial injunctions. So the most prominent example here is the 1933 Norris-LaGuardia Act, which the ACLU had helped to draft. These radicals did not regard civil liberties as bounded by the Bill of Rights. In fact, they often said that civil liberty pre-existed the Constitution. Okay, so the New Deal takes a different approach. This is, they use the state to facilitate labor organizing. NLRA, I'm not going to get into this, did not dictate substantive terms, but it did require the state to intervene to get employers to the bargaining table. There were a couple of groups who opposed the Wagner Act. Communists and other radicals didn't like it, largely because they thought the state would inevitably serve the interests of capital. There were some within the ACLU leadership who agreed. So Roger Baldwin said over and over again that administrative intervention would undermine labor's cause. There was also opposition from committed voluntarists representing established craft unions within the AFL. Okay, notwithstanding all of this opposition, the Wagner Act passed easily, and in July 1935, Roosevelt signed it into law. The modern civil liberties movement had been founded, as I've said, on resistance to state power. And when the state at this time looked like it was ready to come in on behalf of workers, the labor movement set aside its reservations for the most part and embraced government action. But for some of these civil liberties advocates who had taken labor as their primary clientele throughout this period, resistance to state authority had actually become a core unifying ideology for them, both inside and outside the labor context. In effect, these founding leaders of the interwar civil liberties movement had become victims of their own success. To keep the state out of the labor struggle, what they had ended up doing was hitching the right of agitation to the First Amendment. They emphasized a neutral commitment to freedom of speech and association consistent with government oversight of the economy rather than a revolutionary right to restructure government and the economy through collective power, which is what they had started out with. So that is, strikes were legitimate now not because the proletariat retained the right to reconstitute the state, but rather because picketing communicated workers' views. Okay, so the result was a fundamental reshuffling of the civil liberties lineup. The loose coalition of the 1920s was in the process of dissolving. In its place, there were at least 4 competing visions of civil liberties that emerged. This is obviously very schematic, but I think it captures the general approaches to civil liberties during this period. So I'm going to label these 4 visions. The first was the radical vision. This was the one that the ACLU core leadership and some labor radicals continued to espouse. And this account foregrounded the right of agitation. State regulation of labor, they said, slid inevitably into fascism. And these radicals did not regard civil liberties as bounded by the Bill of Rights. In fact, they often said that civil liberties pre-existed the Constitution. The second view was a progressive vision of civil liberties that's still familiar to us today. So it's captured well, I think, in a 1927 quote, "The modern idea of civil liberties grants liberty to men not for the sake of their natural rights, but for the sake of the state." And for many New Dealers, the rights to organize, picket, and strike were derivative of a constitutional commitment to expressive freedom, not civil liberties in and of themselves. This is the understanding we associate today with Justice Holmes and Brandeis and with influential First Amendment theorists like Zechariah Chafee and Alexander Meiklejohn. The progressives were never opposed to state power as such, just to the intrusion of the state into realms of democratic decision-making. And as a result, they were willing to bracket the regulation of labor relations as appropriate for the exercise of state power, as long as rights derived from the First Amendment were preserved. So in other words, for progressives, fundamental transformation of labor relations, of the economic system might be accomplished through the exercise of civil liberties. It might even be a prerequisite for some of them for civil liberties. So John Dewey said, social control of economic forces is necessary in order to render secure the liberties of the individual, including civil liberties. But economic reordering was no longer a civil liberty in and of itself. Okay, a third defense of civil liberties emerged during the 1930s, and this is the conservative vision of civil liberties. And this vision was rooted in a commitment to individual autonomy. On this view, the Bill of Rights was a bulwark against an intrusive state. There were traces of this idea that appeared in 19th century treatises, in classical liberal thought, but conservatives had typically opposed civil liberties claims until this time. They had said, they had distinguished between liberty and license. And in the 1930s, conservatives reevaluated their position on civil liberties for 2 reasons. First, as I've already suggested, a vigorous defense of personal rights could help to counter claims of judicial hypocrisy and buttress the case for judicial review. Second, the New Deal posed an unprecedented threat to the speech and association of conservative groups. Now, I should say here that the progressives were quick to note the resonances between the radical and conservative group views. So the notion that labor relations should be isolated from state intervention clearly smacked of the Lochner-era tradition of economic liberty. And the radicals fought very hard to distinguish their position, not always successfully. Okay, finally, debates over the Wagner Act hinted at a fourth conception of civil liberties, which I call the labor interventionist vision of civil liberties. That vision would take root within the NLRB and its congressional counterpart over the coming years. Like the radical understanding, the substantive, this labor interventionist vision evinced unabashed support for labor's cause, but unlike the radicals and like the progressives here, and I know there are lots of moving parts, but they imagined a strong role for the state in enforcing civil liberties. They protected as civil liberties the rights to picket, boycott, and strike, but also the end goals of civil liberty, namely higher wages, better working conditions, and a stronger position at the bargaining table. There's also a fifth vision. This is the liberal vision, which I started out by talking about, which is our understanding today of civil liberties. I don't have time today to go into the implications of these distinctions, but what I do in the paper and what I'll just sort of flag here is that these different visions of civil liberties manifested in various institutions within the New Deal that were designated for their enforcement. And these were not just competing theories of civil liberties. There were always, of course, competing theories of civil liberties. These were the driving rationales behind important New Deal bodies and institutions. The Supreme Court took, for example, the labor interventionist view very seriously. If you look back, not at the First Amendment cases, but at the labor cases during this period, you'll see language to the effect of Justice Hughes describing the right of employees to self-organization as a fundamental right in Jones and Laughlin Steele. I'll just flag here that constitutional theorist Edward Corwin actually wrote that this is what was radical about the constitutional revolution. There were other bodies that were engaged in this too, though, outside the court, including, I'll just mention them, the Civil Liberties Unit within the Department of Justice, which had a prosecutorial vision of civil liberties enforcement against private actors who were seen to be legitimately infringing civil liberties. The La Follette Civil Liberties Committee within the Senate, which had very much the labor interventionist view as well, and the National Labor Relations Board itself, which opposed free speech as an infringement on civil liberties when it meant the right to distribute, for example, anti-union propaganda against employees. Happy to talk more about this in the Q&A, but basically what we have is these vastly different institutions with competing theories, and for various reasons, it was the liberal vision that prevailed within all of these institutions. Just to speak again to the title of the symposium, it's for today's civil liberties theorists, First Amendment theorists, I think, to consider the implications of given that the groups that were pushing for civil liberties, for a strong First Amendment during this period, were doing it to protect secondary activity, to protect strikes and boycotts, given that those things are likely no longer the agenda of the groups who are pushing for a strong or absolutist First Amendment, it may be worth rethinking whether the costs that go along with that to democracy today are necessarily justifiable. So that'll stop.
Professor Schauer.
We were warned at the dinner last night not to add any additional thanks. I take instructions and rules seriously. So let me start. I want to start by describing two cases. Neither of them are First Amendment cases, but as we say in evidence law, be patient, I will connect them up. So the first case is a 1980, more or less, series of cases, first in the United States District Court in Louisiana, and then in the United States Court of Appeals for the Fifth Circuit. The case is called LaBeouf versus the Goodyear Tire and Rubber Company. So one evening in 1976, Mr. Shelby Leleu and Mr. Floyd Dugas decided that they were going to go out drinking. They started drinking at 9 p.m. and drank continuously from 9 p.m. until 5 o'clock the following morning. At 5 o'clock in the morning, when both of them had a blood alcohol level of no less than 0.18, they climbed into Mr. Leleu's 460 cubic inch, 425 horsepower Mercury Cougar, which was fitted with Goodyear custom power radial tires. Shortly thereafter, on a relatively narrow country road, their speed got up to approximately 105 miles an hour, at which point the tire tread separated from the tire on one of the Goodyear custom power radials. The car left the road at 105 miles an hour. Mr. Leleu was killed, Mr. Dugas was injured, and as you might guess, a lawsuit ensued. A lawsuit against Goodyear. It turns out that the federal district court, applying Louisiana law in a diversity case, applied the Louisiana and now widespread doctrine known as foreseeable misuse. And because the misuse was foreseeable, there was a substantial verdict for the plaintiffs, despite the fact that Mr. Leleu was driving while blind drunk at 105 miles an hour on a small, narrow road. Good judgment against Goodyear. Second case, more or less to the same effect. A more recent case called Osorio versus One World Technologies. First, again, a diversity case, first brought in the United States District Court for the District of Massachusetts, and then upheld by the United States Court of Appeals for the First Circuit. Mr. Osorio was a worker on a construction site, and he was using a job site that is portable table saw manufactured by the Ryobi Manufacturing Company. So Mr. Osorio sets up the saw. That was the first thing he did. The second thing he did is remove the blade guard that is designed to keep one's hand and fingers away from a rapidly spinning piece of sharpened steel. And the third thing he did was remove the rip fence, which those of you who are woodworkers, as am I, understand is designed to keep the wood relatively stable as it goes through the blade. Shortly thereafter, and I won't give you any details, you should thank me for this, shortly thereafter, Mr. Osorio's hand made contact with the blade. Let's leave it at that. He sued Ryobi. The basis for the suit was that Ryobi had failed to incorporate into its saws a modern device that is designed to stop the blade instantly when it makes contact with flesh. This actually works, trust me. The advertisements for SawStop don't use fingers, they use Frankfurters, but this works. Mr. Osorio brought the lawsuit on the theory that by failing to incorporate this technology, Ryobi was negligent. Once again, the plaintiff prevailed despite the fact that the accident would not have happened if Mr. Osorio had not removed the blade guard, had not removed the rip fence, and had not done various other things that were the most immediate cause of the accidents. Now, I'm not interested in the tort law dimensions of this because you have just heard all of the tort law that I know, but What I am interested in is comparing these cases with the analogous ideas, the analogous outcomes, as Eugene Volokh suggested in talking about Rice versus Paladin Enterprises, the analogous situation were situations of this sort to arise in the context of speech. So if I can use some cumbersome language here, the basic issue is, what is the import of there being an intervening volitional actor? That is, what is the import of the fact that Mr. Loyola, Mr. Osorio, and so on had intervened? That is, that in between the alleged act of negligence, whether it be making the tires or making the saw, in between the alleged act of negligence, there was a conscious act on the part of someone else that was the most immediate cause of the accident. This is not in tort law an unfamiliar principle. That is, in tort law, it is no longer unusual that there should be liability in these kinds of circumstances. Not only is foreseeable misuse a common principle, but we also know about dram shop laws that hold taverns and the like liable for the alcohol that they sell to people who subsequently commit or cause accidents. We know about the current debates trying to extend these kinds of laws to the sales of guns and some number of other things. This is no longer surprising. But speech is different. So 2 cases from a bunch of decades ago will make clear just how different speech is. A case also coming out of the Fifth Circuit about 3 decades ago, not that far in time away from LeBoeuf versus Goodyear Tire and Rubber, was Herseg versus Hustler Magazine. Hustler Magazine had an article giving the details about a practice known as autoerotic asphyxiation. I'm not going to describe that in any more detail than I described Mr. Osorio's accident, but the article fell into the hands of a 14-year-old boy who tried it and was found dead by hanging under the noose with a copy of Hustler Magazine open to this article under his deceased feet. Wrongful death suit was brought against Hustler Magazine. The Fifth Circuit ruled that on the authority of Brandenburg versus Ohio and on the authority of the First Amendment, there could be no liability for Hustler, despite the foreseeability that something like this might happen. At more or less the same time, the California Supreme Court decided a case called Olivia N. versus NBC. NBC had broadcast a television show or a made-for-television movie called Born Innocent. It described in a particularly grotesque form of sexual assault. A group of young men committed a remarkably similar sexual assault almost immediately thereafter. The victim sued NBC, the Supreme Court of California, again on the authority of the First Amendment, on the authority of Brandenburg versus Ohio, refused to find that there was any liability. Indeed, we might suspect, and we probably should suspect, that even if the actions had been intentional on the part of a speaker or writer or publisher, the outcome would be the same. So I mentioned Brandenburg versus Ohio, the well-known case that creates a great deal of modern free speech law. Clarence Brandenburg was a leader of the local Ku Klux Klan in Hamilton County, Ohio. At one point, he was giving a speech to his fellow Klansmen. And during the speech, he promised or threatened acts of revengeance. That's not a word, but it's the one he used. It's not in your dictionary. Acts of revengeance against African Americans and Jews. He didn't use those words either. But He was prosecuted under the Ohio Criminal Syndicalism Act. The Supreme Court unanimously overturned the conviction, and the Supreme Court's opinion created a great deal, or almost all, of modern First Amendment law regarding advocacy of unlawful conduct and so on. Even though Clarence Brandenburg's words were somewhat opaque, under those circumstances we can suspect that even if he had more actively urged these acts, the fact that he did not urge that they take place imminently, the fact that they were not likely to take place imminently, probably would have immunized him from liability, even if one of his hearers had gone out to commit a violent act of revengeance inspired by Brandenburg's speech. What all of this suggests is that in the context of, again, I will repeat, the intervening volitional actor, the 14-year-old boy in Herseg, the group of young men in Olivia N., the possible hearer of Brandenburg's speech. In the First Amendment context, the existence of an intervening volitional actor will prevent liability. That is, if I urge you to do something and you go out and do it, you're the one that's responsible and not me for having urged it. On the other hand, when we are thinking about tort law, as in Osorio, as in LaBeouf, as in vast numbers of other vicarious liability situations, the law is very different. So then the question is, what is the difference between how tort law treats the intervening volitional actor and how the First Amendment treats the intervening volitional actor? Now, one response to this is the First Amendment is in the Constitution, and all of this other stuff is not, and as a matter of positive law, that's just the way it is. Deal with it. Now, this panel is supposed to be about First Amendment theory, so although that may very well be true, I want to try to scratch a little bit deeper than the deal with it. The First Amendment is there in the Constitution, and other restrictions on tort law are not. Another possibility is that speech in general, as a category, is less of a contributing factor, less causal, less influential in producing subsequent violent or unlawful or dangerous actions than various kinds of acts are. Maybe. And I leave this as a maybe, despite a vast amount of civil libertarian rhetoric to the contrary, and despite as the dean mentioned earlier this morning, the ubiquitous incantation of the sticks and stones idea, it is by no means clear that acts of communication, acts of speech, words, press, and everything else are, as a category, less causal of subsequent actions than a various number of actions. Of course, it is true that almost all speech is harmless. But it is also true that almost all actions are harmless. So the relevant question to ask is whether the category of causal harmful speech is larger proportionately than the category of causal harmful actions. I don't know, you don't know, nobody knows. It's the right question to ask. There may not be any answers. My own suspicion is that some of what's going on in the rhetoric about all of this is a phenomenon that I like to refer to and have in a couple of previous writings as First Amendment opportunism. First Amendment opportunism is the idea that there are some number of broad and not speech-specific views about how to set up a government and how to set up the law. And people who have those views often discover that the First Amendment is a good way to articulate those views, a good way to embody those views in positive law. That is, if you don't like government interference, in general with business practices, One way to embody that is to object to government interference with commercial advertising. And indeed, in an important article 30-some years ago by my colleague John Jeffries, along with former dean of the Virginia Law School, Tom Jackson, they argued that the entire commercial speech revolution, the entire protection of commercial advertising, was actually an example of this kind of opportunism. That is, that what was going on was basically an objection to government regulation, not anything that had anything to do about speech. We can see this in some of the cases that I was just talking about. There are lots of people out there. Let me change the there. I suspect very strongly that there are lots of people out here who probably think that LaBeouf and Loyola should have lost. There are probably lots of you who think that Osorio should have lost. There are probably some of you who don't like the idea of dram shop liability for restaurants and bars that sell alcohol. And I'm sure that there are people here who fully subscribe to the guns don't kill people, people kill people slogan, which is again an embodiment of the same idea. Let's call this libertarianism. Some of my best friends are libertarians in this sense. It is a more than plausible political position. But one of the things that may be going on in the free speech area is that this is an embodiment of a somewhat or substantially broader libertarianism and has little, if anything, to do with speech itself. It's just that this is the most convenient, the most opportunistic way of embodying a general view about the a general view about the inadvisability of holding people other than the last volitional actor responsible for what happens. Once we recognize the distinction between what would happen in tort law and what would happen as a matter of First Amendment law, we can recognize that some number of people, including the speech victims that I have just described, might be able to recover as a matter of tort law, but can't recover precisely because the speech was involved rather than table saws, rather than tires. Once we recognize that these people would otherwise be able to recover, then we can understand that the First Amendment and the idea of free speech has costs. That is, liability that would otherwise be available becomes unavailable. That's the cost. And a very important question that I am not going to answer this morning is, once we understand that speech has costs of this variety, who should pay them? Under existing law, the costs of speech are almost entirely borne by the victims. They are borne by the victims of the kind that I have just mentioned, who are unable to recover in ways that they would be able to recover if they were the victims of something else. That's a difficult problem. I don't have a quick answer for it, but it seems clear that we ought to think a little bit more before we so quickly assume that the costs of a free speech regime, which in theory benefits all of us, should be borne entirely by the victims of harmful speech. So I will close with a line that is not original to me, but maybe the single best opening line ever written in a law review article. There is no such thing as a free speech. Thank you.
It's an honor and a pleasure to be here. Since I couldn't be at the dinner last night, I can thank the editors of the Emory Law Journal for inviting me and for their gracious hospitality. On Monday, January 12th, I argued a First Amendment case in the Ninth Circuit, Arce versus Huppenthal. It involves an Arizona law that was designed to eliminate Mexican-American studies courses. One provision of the law prohibits courses or classes that promote racial resentment. Another prohibits courses or classes that are designed primarily for students of ethnic minorities. Another provision prohibits courses or classes that advocate ethnic solidarity instead of treating pupils as individuals. My central argument to the Ninth Circuit, and the central argument in the briefs, was that this law is unconstitutionally vague and overbroad. I'm cautiously optimistic that the law will be struck down on that basis. But as I reflected on the briefs and the oral argument, I realized that something important was missing. That the Arizona law really was about trying to control thoughts of the students and even of the faculty. Look at the language of the statute. It prohibits courses or classes that promote racial resentment. Isn't that all about a type of thought? It promotes advocating ethnic solidarity. Isn't that about stopping a particular kind of thinking? In fact, on Friday, January 2nd of this year, the then Secretary of Education, Huppenthal in Arizona, sent a letter to the Tucson Unified School District that they were in violation of the statute, and he gave examples. He said in a history class, one of the prompts in an exam talked about the brutality of American slavery. He pointed to a music class where they were teaching hip-hop music, and he had pointed to a Mexican-American history class that talked about the suffering of Mexican-Americans in the United States. Isn't all of that about trying to stop a certain kind of thinking? Richard Delgado, who is here today, wrote a terrific article where he talked about the psychological effects of laws like Arizona's. So the question you can ask me is, as an advocate, why didn't I, at oral argument in the briefs, talk about freedom of thought and freedom of conscience? And the answer is that the doctrines of the First Amendment don't focus on this. The theories of the First Amendment don't focus on this. I decided to do a Westlaw search and just simply type in the phrase freedom of conscience. There are only 44 times in all of American history that the Supreme Court has used that phrase, and almost all are in the religion context. I did the same thing for the phrase freedom of thought and discovered exactly the same result. So I decided I wanted to work on a project that focused on freedom of thought and freedom of conscience as central values of the First Amendment. In this brief presentation, I'd like to emphasize 3 points. First, that freedom of thought and freedom of conscience are largely absent from the theories of the First Amendment. Second, that freedom of thought and freedom of conscience should be regarded as central values of all parts of the First Amendment. And then third, I want to spend most of my time talking about how there are important doctrinal implications if we would focus on freedom of thought and freedom of conscience as the underlying values of the First Amendment. A couple of disclaimers. I am not saying that freedom of thought and freedom of conscience are the only values underlying the First Amendment. This in no way is rejecting other theories that have been done. What I'm arguing is that these are values that have not been focused on nearly enough by theorists or by courts. Of course, the fact that freedom of thought or freedom of conscience are values doesn't necessarily decide cases. There can be a compelling government interest for restricting speech, even if the effect is to limit freedom of thought or freedom of conscience. I should also, by disclaimer, say that I'm at the early stages of this project, and of course, even in 15 minutes, I can't develop all of the aspects of it. Perhaps most importantly, I'm not going to try to defend for you why freedom of thought and freedom of conscience are important values. No, I'm going to try to defend freedom of thought and freedom of conscience. I believe I can proceed with this talk with the general understanding we would have that freedom of thought and freedom of conscience do matter, and that we do have a shared understanding of what's meant. The first point that I wanted to make was that freedom of thought and freedom of conscience are largely absent from the theories of the First Amendment. Let me start here with freedom of speech. There's the most theorizing about why freedom of speech is regarded as a fundamental value. If you pick up any of the case books about First Amendment law, they always identify 3 crucial values that are served by the First Amendment. The first is the relationship between freedom of speech and democracy. Freedom of speech serves a key instrumental function in democracy, allowing people to be informed so elections are meaningful, speech which can check government behavior. The problem, of course, with this as a theory of the First Amendment is it's so incomplete. No one would dispute that freedom of speech is protected because of its value with regard to the political process, but First Amendment protection of speech isn't limited to political speech, nor should it be, nor is it easy to separate what's political from other types of expression. Second theory that's often advanced for protecting freedom of speech as a fundamental right is the way which contributes to the marketplace of ideas. This, too, looks at freedom of speech from an instrumental perspective, how it's leading to other benefits. Many theorists have talked about the fallacies of the marketplace of ideas, how imperfect the marketplace of ideas is, how it may not even be a metaphor that describes what goes on in society as to speech. Final theory with regard to why freedom of speech is a fundamental right focus on individual autonomy. And this is closest to what I'm talking about. So I went back and read the leading articles that defend freedom of speech as a function of autonomy. Professor Martin Reddish of Northwestern University has written one of the leading articles in this regard. But if you focus on his article, what he's talking about is expression itself being an aspect of autonomy. By speaking, we are exercising autonomy. I want to focus on something different. I want to focus on what I would say is the underlying value that freedom of speech as autonomy serves, or freedom of thought, or freedom of conscience. And interestingly, that's absent from the treatment in Professor Reddish's article or from those who treat freedom of speech as fundamental because of the way in which it advances autonomy. In their absence, I think, makes them vulnerable to a key criticism. The late Robert Bork said, "Why should we value freedom of speech as an aspect of autonomy compared to all of the other actions that somebody might enter into?" I suggest to you, if we focus on speech as a way of furthering thought and conscience, then we have an answer to Robert Bork's question. There are also theories as to why we protect freedom of religion. There are theories that underlie the Establishment Clause. But once more, if I were to go through them for you, I think I could show you that they never focus on this in terms of freedom of thought and freedom of conscience. So the second point that I wanted to make for you was that freedom of thought and freedom of conscience are crucial values with regard to all aspects of the First Amendment. Start with the religion clauses. Why do we care about freedom of religion? I don't think that it's coincidental that the framers of the First Amendment put religion first within it. I think that the framers of the Constitution were especially concerned about religious conscience. They believed that a key part of a person's life was to form religious beliefs and then to be able to practice them. That's what the Free Exercise Clause of the First Amendment is all about. I think it's also what the Establishment Clause of the First Amendment was all about. The framers of the First Amendment were deeply distrustful of government power. They were particularly concerned about how government power in the area of religion could affect people's practices, and by affecting their practices, even affect their thoughts. It's easy to explain why freedom of speech underlies, freedom of thought and conscience underlie freedom of speech. How do we develop our ideas? How are our thoughts formed? To a large extent, it's by what we read, what we listen to, what we hear. And we formulate our thoughts, too, by what we say, how others react to what we say. From this perspective, it's easy to see the relationship between freedom of thought and freedom of the press. One of the key ways that we can receive information is from the press, broadly defined. I believe that the other parts of the First Amendment were meant to protect the ability of people to act upon their thoughts and ideas. Freedom of assembly, the right to petition government for redress of grievances. Provisions of the First Amendment that are so often ignored, seen in me from the framers' perspective about the ability of people to take their thoughts and get together with others, try to persuade government to implement it, to petition government to make changes. Now I have framed this in terms of what those who drafted the First Amendment thought. I'm not an originalist, and whether the freedom of conscience and freedom of thought were really what they had in mind is largely incidental to the argument I want to make. But there's a stunning new book that's just been published. It's by Bert Newborn, an NYU professor, titled Madison's Music, in which he argues that there is a central aspect to the First Amendment. There is a unity of its provisions. And what I would add to Professor Newborn's analysis is that freedom of thought and freedom of conscience underlie this. Well, if you'll accept what I've said so far, that freedom of thought and freedom of conscience haven't been the focus of the theories of the cases, and yet from even a common sense perspective, freedom of thought and freedom of conscience are central underlying values, I can then move to the third and final part of my remarks. What I want to spend the most time on is thinking through what are some of the doctrinal implications of focusing more on freedom of thought and freedom of conscience. There are many. Let me start with something that's been so much in the news and in the law reviews in recent years. What are the First Amendment rights of corporations? Corporations can't have freedom of thought or freedom of conscience. And so from this perspective, it wouldn't make sense to accord a corporation First Amendment protection. And yet, that's too simplistic. If you accept what I said in passing a moment ago, that the way we formulate thoughts is hearing others, what corporations say then can influence the freedom of thoughts that we have, and then corporations should have free speech protection. They're not given free speech protection because of an autonomy interest. It's an oxymoron to speak of a corporation having autonomy, but we would protect corporate speech because of the way in which it benefits the rest of us. It's protected from instrumental perspective. In fact, if you look at the first Supreme Court case to ever extend free speech rights to corporation, First National Bank of Boston versus Bilotti, the Supreme Court said that's exactly the way to protect corporate speech rights. Now, this doesn't mean that Citizens United was correctly decided. I believe it was wrong because I believe there are compelling interests that justify restricting corporate political expenditures, preventing corruption, equality in the political process. But it does mean that those who say that corporations shouldn't have speech rights are wrong because corporations should have speech is a way of informing the rest of us. But I think this provides a key way of distinguishing the speech rights of corporations from the religious rights of corporations. On June 30th of 2014, in Burwell versus Hobby Lobby, the Supreme Court held that it violates the Religious Freedom Restoration Act to require that a close corporation provide insurance benefits with regard to contraceptives that violates the owner's religious beliefs. Justice Alito, writing for the majority, said that the corporation is a person and that the corporation can claim religious beliefs. But how can a corporation have a religious conscience or religious beliefs at all? Now, Justice Alito said that those who form a corporation should not have to give up their religious beliefs by choosing to incorporate. It's important to note that's a very different argument that was made for why corporations have speech rights. It also, I think, ignores the distinction between individuals and corporations. If I want to form a business, I can run it by my religious beliefs so long as I don't violate any of the laws. I form a corporation to protect myself from liability. I want there to be an entity that is separate from me. Once I've created that separate entity, it can't have a religious conscience or religious beliefs. And in this way, I think focusing on thoughts and conscience is underlying the First Amendment, shows why Burwell versus Hobby Lobby and extending religious beliefs to corporations is misguided. Another doctrinal benefit of focusing on freedom of thought and freedom of conscience is I think it will help reconcile some of the tensions that have long existed between the Establishment Clause and the Free Exercise Clause of the First Amendment. Many have written about these tensions. Let me give you a simple example. If the government pays for chaplains for those in the military or prisons, isn't there an Establishment Clause problem? But if the government doesn't pay for chaplains for those in the military and prisons, isn't there a free exercise problem? I think if you focus on this in terms of freedom of thought and freedom of conscience, you can cure that problem. Because if the government is providing for ministers, those in prison or those in the military, it is facilitating freedom of thought and freedom of conscience, and therefore it shouldn't be seen as violating either free exercise or the Establishment Clause. But But I think the most important doctrinal implications, and the ones that I most want to write about, are how it changes free speech analysis if we focus on freedom of thought and freedom of conscience. Let me just quickly mention a few examples. I think it changes the nature of obscenity law. When the Supreme Court said in United States versus Roth that obscenity is not protected by the First Amendment, it defined obscenity as material that appeals to the prurient interest. If you look up prurient in the dictionary, it says that which excites lustful or lascivious thoughts. That would then mean that laws that prohibiting obscenity are by their very nature meant to change thoughts. The government shouldn't ever be able to change thoughts. The government should only be able to regulate behavior. Another example concerns chilling of speech. In many cases, the Supreme Court has said that chilling of speech is not sufficient for a First Amendment claim. In Laird versus Tatum in the early 1970s, the Supreme Court said Army spying on civilian groups doesn't violate the First Amendment because chilling of speech isn't sufficient. In Younger versus Harris, 1971, the court repeated that. Most recently, in Clapper versus Amnesty International, in 2013, the court said that chilling of speech isn't enough for standing. But if you focus on freedom of speech in terms of freedom of thought and freedom of conscience, I think you can see why chilling of speech strikes at the very heart of the First Amendment. Because if speech is chilled, then people can't receive the ideas that are necessary for formulating thoughts. They can't express themselves in a way to do so. One final example about this, and that's the right to receive information. There are a handful of Supreme Court cases that have spoken in passing of the right to receive information, but this is a right that's never been developed by the Supreme Court. In my quick explanation of why freedom of thought underlies freedom of speech, I focused on the right to receive information to formulate one's thoughts. So the right to receive information should not be seen at the periphery of the First Amendment, but at the very core of what free speech protects. I think this is important in terms of some of the provisions of the First Amendment that have gotten little attention. Freedom of press, for example, has been interpreted by the Supreme Court to be largely redundant with what's protected by freedom of speech. This seems to me wrong, because freedom of press is crucial from the perspective of formulating thoughts and conscience as people develop their ideas. The focus of this conference is freedom of speech in the early 21st century. We are, at this point in American history, a deeply divided society. We're deeply divided on almost all political, social, and legal issues. One of the appeals to me about focusing on freedom of thought and freedom of conscience is that those are values that are accepted by all. There's a rhetorical benefit in talking about freedom of speech in terms of freedom of thought and freedom of conscience. There's a rhetorical benefit in thinking of all of the First Amendment in this way. We may still disagree about how these values play out, what interests are sufficient to override them. But wouldn't it be good at least to start the conversation with values we all can agree on? And aren't they that freedom of thought and freedom of conscience are crucial to all of us? Thank you.
Thank you so much. I'm fortunate to be at the end of this tremendous group from whom I just learned so much in the hour that we've been listening to them. I do want to express my thanks to the Thrower family, who has been tremendously generous, both to us in this conference, but to the intellectual life of the Academy as well for so many years. For Emory Law School for sponsoring this, and more than anything for Ben Klebanoff and Gerard Bufolko, whom I've had the pleasure of working with on this conference. I've done numerous symposia, and I can tell you I have never worked with students who were so involved and so engaged and so willing to discuss and improve and to spend so much time on a conference as Ben and Gerard. And it was a tremendous privilege for me to have been able to work with them. So what I want to speak about today is about the general theory of free speech. I take a much broader approach than anybody who's spoken so far, because I conceive of free speech as being among the structural values of the United States Constitution, so that the function of speech is one that plays into the fundamental purpose of the Constitution, which is protecting individual rights for the common goods. That means that my theory is synthetic. It does not isolate free speech as a lone value. It has deontological and consequentialist implications, which I will explain. But to put them briefly, it means that the right of free speech is both individual and collective. It is textual in the sense that it looks to the Constitution but is not pinned by the Constitution, and requires the court to use contextual analysis, which is a balancing form that the court has tried to disavow in some recent cases. So I want to begin by reiterating a little bit about what Erwin said in his earlier remarks, but not spend much time on it because he did such a good job in speaking about the three principal theories of free speech doctrine and their weaknesses. They all have kernels of truth to them, but yet they're too narrow to explain the value of free speech in our representative democracy, which I think facilitates political engagement, personal development, and the pursuit of happiness, something that I believe is too rarely spoken of in the context of speech or the Constitution in general, which of course is derived from the Declaration of Independence, which typically is spoken of as a form of overexpressive generality, but I believe has actual substantive constitutional value. So let me begin with this theory of autonomy. As Erwin said, that there are some valid reasons, obviously, for believing this. Much of them is that what we say is very much intrinsic to our points of views. Laura also spoke about this as a natural rights theory, that it is pre-constitutional rather than positive. You could think of it in positive terms. The article that Erwin mentioned by Marty Reddish claims that free speech, is the only value of free speech. There are others, but that is the only one, the quintessential. All the other values are explained by it. Edwin Baker takes a very similar position to the standpoint. So it's not that they're arguing that there are multiple values and it's just amongst them, but rather that is the only value of free speech, and some other people argue the same. I think that Justice Brennan, in one of his dissents, got it right in arguing that while obviously speech is critical and intrinsic to human dignity and liberty, it also advances society's search for truth, so that there is a social value as well. Clearly, litigants, soapbox speakers in public parks, lobbyists, and pundits understand that there is a self-fulfilling role of going out there and being able to cathartically speak one's mind, and yet their speech, their expression, has an invaluable role in our representative democracy, so that these things are combined rather than simply singled out as only having to do with individual speech. In fact, there are various aspects of speech, even though differentiated typically from the First Amendment and copyright, that I think are inexplicable if only the autonomy model is right. So in the copyright area, the Supreme Court has said that not only is copyright law there in order to protect individual creativity, but also because it stimulates artistic, because it also is also beneficial for the general public good. So an integration of this deontological and consequentialist point. this dual purpose requires legislators to balance between, this is straight out of copyright, to balance between the interests of authors and inventors in the control and exploitation of their writings and discoveries on the one hand, and society's competing interest in the free flow of ideas and information. In other words, that there's a balance going on between individuals' ability to have a property right to their individual creativity and society's interest to know, this idea expression dichotomy. Something that I think the First Amendment is unfortunately left out by the court in a variety of cases in the Supreme Court, but yet something that has a balance that is required rather than something that's very categorical and particular about speech. The other major model, which Erwin also mentioned, is the democratic governance model, and this also Laura spoke about. This is from Meiklejohn, and then Robert Post has picked on it very much, that we're a democratic citizenry that has to have the ability to educate our fellow citizen, and that is core to the our principle of free speech. The difficulty is one that Eugene Volk pointed out in the context of press, but is applicable here, and that is that trying to identify what is political is quite difficult, or very often one's views about the Religious Freedom and Restoration Act, or the Violence Against Women's Act, or what have you, being able to speak those matters out is both an act of politics and an act of self-expression. And then the other thing that the democratic model doesn't explain is why works that have absolutely nothing to do with politics are protected, such as the picture of Dorian Gray or some of Wordsworth's poetry, such as My Heart Leaps Up. Moreover, I can't imagine that anybody, certainly not in the Supreme Court, and I'm certain not in this room, would ever think that it would be wrong for me to write a poem purely for the purpose of writing the poem and then throwing it in the fire. That's clearly an act of personal free speech, but it has nothing to do with politics. I don't even intend anybody to look at it. And so this democratic view, which is clearly right on some points, is also too narrow. The marketplace of ideas also doesn't explain a variety of speech. So just recently, the court ruled that falsely stating that an individual has military honors is something that's protected. And there are just a variety of hyperboles, parodies that are protected by free speech that clearly have no truth value and have a variety of different functions. So where my theory differs from the common free speech view that just wouldn't take any of these and perhaps would synthesize them all together into something is that I want to say that free speech is a component of our structure of representative democracy. That representative democracy is one that's built on the concept of individual dignity and government's obligation to protect the general welfare. So the First Amendment should be understood as an essential component in this structure that derives from both the Declaration of Independence and the preamble, things that are typically not conceived as having any substantive value, but ones that I think frame our entire system of representative democracy. A theoretically satisfying explanation of the First Amendment has to go hand in hand with our view of representative democracy. And my argument is that individual rights are ones that are protected insofar as individuals have no conflict. But government only has some basis of entering into the fray when there is such disagreement, and that could be a variety of things. It could be defamation, it could be libel, it could be truth threats. And so the role of the First Amendment is for people to be able to identify something that's core, something that's fundamental, and I would say something that's natural to human beings. That is, all of us in a pre-political world are born with the right to be able to express ourselves, whether that is through organized language or grunts or movements or other visible forms of communication. And yet, so many scenarios require protections that cannot solely be taken care of on an individual basis. For example, issues where the individuals have a greater resort to power. In copyright is another example that I can give where I've already spoken about it, but the copyright owner often has much more authority, particularly where there are corporations that own a particular copyright, than an individual who wants to be creative. And the law is there in order to protect that ability to have some sort of engineering and innovation and development, which is good for us as a society and not only just the individual. The First Amendment, then, is not exclusively concerned with self-expression or self-government, but a combination of the two. Everyone is free to express a view, but where such expression intrudes into legally cognizable interests of other people, then the government is empowered to pass a narrow range of regulation. These two values of speech are part of an overall structure of a constitutional system opposed to the suppression of the individual in his or her private capacity, but also in the suppression of the individual in the civic capacity. So I want to give a few examples because I know that this theory is too nebulous to really try to figure out what it means without having some sort of particulars. I want to give three examples. The first one's going to be defamation law, the second, intentional infliction of emotional distress doctrine, and the third being the true threats doctrine. So why then is defamation an exception from the typical protection of free speech under the First Amendment? It's because we value autonomy and the general welfare. It's not captured by the autonomy model and not even by the democratic model, because those alone cannot explain why false statements receive a higher standard of proof. So in New York Times v. Sullivan, what the court teaches is that there is a personal and a public level of being able to express oneself that can go too far and has to be protected. The equal right to voice views on social policies allows individuals to fulfill their roles in their personal sense and in their life mission, and to participate in rational debates in civil advancement. Ideally, speech should lead to truth, but the reality is that ordinary conversation involves hyperbole, one-sidedness, error, and all manner of misstatements. Speech provides a personal outlet for anyone wishing to express convictions to the public and the private sphere, even when mistakes slip into the conversation, and allows individuals to mobilize others to achieve social advancement, which for Sullivan was desegregation, right? The advertisement in New York Times v. Sullivan was clearly wrong. There were many mistakes in it. There were mistakes about the place, the amount of force that were used, and yet it was the key was that it was an expression of something that was civic and spoke against segregation. Thank you. So it had something that where it was civic and had a social component to it, had a First Amendment right. But defamation law, where we as individuals speak in all sorts of hyperbole and whatnot, and inaccuracies, should not be suppressed and not be prevented from speaking our views. So there's a balance there, right, between the personal and the public. Where the public comes in, then when the public interest comes in, then there's far more public interest in allowing the common good to progress, even though there are some defamatory statements that can be made as long as they're not malicious. With intentional infliction of emotional distress is another case where the court clearly balances the private against the public, right? Why? Well, because ordinarily, in ordinary intentional infliction of emotional distress, that type of speech can be suppressed, right? You can't come up to someone and act outrageously and say something that causes some sort of harm where there's an imminent component in it. But where in Snyder v. Phelps, a case that recently came out about funeral protests, the court was very specific that there is a First Amendment free speech interest where the public is interested in the message. There, the vile statements that were made about Jews, blacks, and gays and Roman Catholics by the Westboro Church were ones that were protected. They're public issues that could be spoken about. But that's why the intentional infliction of emotional distress there did not allow for a cause of action to proceed, while ordinarily, where we're dealing with just private individuals, it is allowed to proceed, and therefore it's necessary to contextualize the First Amendment for the courts and for us as far as looking both at the individual component and the public component as well. The last example I want to give is one of the true threats doctrine. Now, Fred spoke about Brandenburg, and Brandenburg is about incitement. I respect deeply what he said, but I do think that there is a big difference between the lack of scienter proof in Brandenburg, which called for an imminence, that is to say a mind frame, and in the true threats doctrine, which is Virginia v. Black, where there was a need for some sort of mental component. And I do think that if you can prove up that there's an intent to try to incite, you don't even have to prove imminence. There is no imminent component in Virginia v. Black. So allowing racists and ethnocentrists to incite to fall under the incitement to fall under the protection of the First Amendment overemphasizes free expression and gives too little consideration of how hate speech threatens constitutional order and public peace. Fred spoke about this in the context of maybe we're overemphasizing it to the diminution of the harm of the individual. I want to think about it in the context of public order and public speech. Eugene also discounted the European model. He said he's glad to live in the United States, and I too was born in the Soviet Union just like he. But yet I do think that the European Union has gotten it right, and we have fallen short. And what I mean by that there's an argument by Robert Post, for one, and by many others, about that democracy might suffer if we don't allow the speech of racists and homophobes and what have you with an intent. Notice I want to be very clear. I'm talking about with the scienter component to proceed. And yet we have many examples of democracies that function just fine and are very pluralistic and have laws that prohibit certain forms of racism and discrimination. Canada, France, Germany, Austria, Norway, Sweden, Switzerland. I mean, you could just go on with this list. Hate speech subsumes antagonism, dehumanizing, and threatens particular groups, such as those defined by class, ethnicity, race, gender, color, religion, and sexual orientation. Opponents of hate speech regulation often lean in the marketplace of ideas doctrine, but this seems to be ineffective in explaining the maintaining of the First Amendment protecting the expression. The court has pointed out that fighting words which can provoke a brawl, such as those that have such a slight social value that social value outbalances the need to suppress, the volition to be able to express oneself can be limited. And so I think that what should be thought of in this context and the way to perhaps reconcile Brandenburg and Virginia v. Black is through this model that has an analysis both of the autonomy and the democratic value. I apologize, I'm out of time. You can see how many pages I'm leafing through here. So let me be very quick in finishing, just a couple of seconds here. Even without going through this, my basic argument is that free speech and its protection under the First Amendment is part of the structural value of the Constitution. We should not isolate speech and try to take it out of all other constitutional values. It is there to protect individual rights for the common good.
Well, thank you. Thank you to all four of our speakers for this fabulous insight into and the big picture idea to set the tone for the rest of the symposium. Do we have a few minutes for questions and answers? Okay. First, I guess I want to ask the panelists if they have any comments or questions for one another.
I'd rather hear from them.
Okay. Okay. They'd rather hear from you.
Yeah, thank you all of you for your presentations. I'm going to drag us perhaps into the 21st century in a hurry. These little devices in our pockets are pretty amazing, and I understand that there may be some question recently about whether there is some First Amendment protection for the conduct of using a device like this to record the behavior or misbehavior of government authorities, particularly those in law enforcement. I haven't really articulated this question yet, but I'm going to throw it out there. I'm wondering how your views of the First Amendment come into play when deciding whether there is a First Amendment right to record that conduct or misconduct.
I'll say something, but may not be directly responsive. I should say, in response to what you said about various theories of the First Amendment, I don't have one. The smartest thing that Oliver Wendell Holmes, who said lots of smart things, ever said was, give me the insights, I care nothing for the theories. Actually, he said systems and not theories, but you get the idea. I'll leave the big picture to others. I think there is an interesting question embedded in what you said. That is, one issue is what are the circumstances under which we should hold government officials accountable? And the other is the question of, is the mere fact that one is using a telephone, camera, recording device, and so on, sufficient to trigger a First Amendment variety concern as opposed to just a more broad-based concern about restricting government abuses that might include things that have nothing to do with the First Amendment. For example, the general area of civil liability under Section 1983, a whole range of other things that are not particularly speech protective. So I guess my response relates a little bit to what I said about opportunism. I think we first have to decide whether we think we need more or less restriction on police officers, more or less restriction of government officials. That's not a free speech question. That's a broader and bigger question. If the answer to that question is we think we need more, then maybe we can take the First Amendment off the shelf and opportunistically use it for what is in fact another purpose.
I have a simpler answer, I think, and certainly a more direct answer. I think that checking government is a central value of free speech and free press. I think Vince Plazzi wrote a very famous article in the ABF Law Journal that argues this well. I believe that gathering information is a crucial aspect of the First Amendment. So in terms of taking the video of what the police are doing, I think there's a First Amendment right for people as part of checking what their government is doing, as part of gathering information to do that. The question would come to me in terms of, might there be limits on the ability to post the video that's shown? And I can imagine instances where there'd be a compelling interest that would justify it. I could think of the privacy interests of those who are interacting with the police in certain instances justifying restriction on posting. I could imagine if it would reveal certain secret law enforcement practices that they want to be able to justifiably not have revealed. So I think the gathering of the information is protected. I think generally the posting of the information protected by the First Amendment. I think there could be compelling instances, in particular instances, in which this could be limited. And it's not just in terms of the police. A number of states have adopted laws that are referred to as agricultural gag laws that prevent people from recording what's going on in the livestock area to prevent the exposure of unsanitary and inhumane practices. And these laws are now being challenged successfully, thankfully, on First Amendment grounds.
I think we have time for one more question.
Why do you think there's such a dichotomy between the First Amendment doctrines that academics find convincing and the doctrines that judicial opinions often cite to say that it fully animates the essence of free speech?
It's interesting, actually. I mean, there is a disconnect, I think, in the way that free speech grew up in the academy over after the 1930s, in the aftermath of the New Deal, and the way that the courts interpreted it. I think the courts. I mean, I have an answer. I suspect I have an answer that's in some sense less theoretical. Others on the panel would probably respond differently, which is that courts, more I think than academics, are moved by social movements, by lawyers, by litigants, by actors on the ground who are shaping the sorts of questions that the courts are hearing and the way in which they frame their judicial opinions. So actually, it turned, in my talk, I didn't explain why the liberal vision prevailed. The liberal vision prevailed largely because of successful coalition building between the ABA and the ACLU and the National Association of Manufacturers and the U.S. Chamber of Commerce and other groups that all had a certain ideological consensus around a certain vision of free speech, and were able to sort of find common ground in the way they crafted their briefs and arguments in a way that the court was therefore more receptive to. So I think often, the courts are certainly motivated by theory, but they're in some sense more motivated by the legal actors in front of them.
I can only just add something very briefly. I completely agree with what Laura just said. I do think that there's also an element of opportunism. What in another context Scalia said that he's a fair weather originalist. Right, so you look at the theory that fits what you want to say, you put it in the context. It's Babbidian. So Phil Bobbitt came up with these different lexicon ways of speaking about law. You put your argument within the context of something, and sometimes it's a very outcome determinative, and you make your argument, and it doesn't bootstrap you as much if you don't have to adopt a particular theory, right? It leaves more freedom to be able to enunciate a holding, where I think academics strive to consistency or to identify and to admit to error in previously conceived theories.
Let's not forget that much of what passes as free speech theory in the public arena and judicial opinions are better characterized as slogans rather than theories. The marketplace of ideas, truth wins out. The remedy for bad speech is more speech. The slippery slope, the thin edge of the wedge, who's to say, where do you draw the line, the parade of horribles, and so on. Slogans are all over the place in the world of free speech. Maybe it's the job of the academic to look behind the slogans.
I think that's a great line on which to end this panel. Please join me in thanking all of the speakers one more time. I think we're going to get some instructions for lunch.
Yep. So it is now lunchtime. I've been asked by operations, if you notice there's a door over here to my left, if we could proceed out of that door, that's where the food is actually located. So you can walk past that and then move to the tables. Thank you very much.